If you are planning to board a flight out of the United States, or if you are waiting to fly back in, I need you to stop whatever you are doing and watch this video, because what I am about to share with you could change everything. Right now, in 2025, ICE, that is U.S. Immigration and Customs Enforcement, has dramatically increased its presence at American airports, not just at international arrival halls. We are talking about departure gates, connecting flight terminals, and even domestic airports in some cases. And there are 4 specific types of immigrants, 4 groups, who are facing a very real, very serious risk of being stopped, detained, questioned, or denied re-entry every single time they travel. This is not based on rumors. This is not social media fear. This comes directly from official enforcement directives, federal court filings, and documented cases happening right now across the country. Stay with me, because this information could protect you or someone you love. Welcome back to Immigration Radar USA, the channel where we cut through the noise, skip the panic, and bring you real, verified, and actionable immigration news. My name is Host Name, and if you are new here, every single update we share on this channel is sourced from official government publications, USCIS announcements, U.S. Customs and Border Protection guidelines, federal court records, and statements from licensed immigration attorneys. We always put our sources in the description below, and we always encourage you to verify information with a qualified professional before making any decisions. Now, today's topic is one of the most important we have covered this year. We are talking about ICE enforcement at U.S. airports. What has changed, who is at risk, and what you can do to protect yourself. To be clear, this video is not meant to create panic. Most immigrants travel without any issues every single day. But if you or someone you know falls into one of the 4 categories we are about to discuss, there are real risks you need to understand. Ignoring this information is not worth the gamble. Let us start with some background on what has actually changed and why airports have become a major enforcement focus in 2025. For many years, immigration enforcement in the United States was largely focused on the border, the southern border especially. Airports were considered lower priority enforcement zones, and most immigrants flying domestically or returning from short international trips did not face serious scrutiny beyond a routine CBP inspection at the port of entry. That changed significantly in early 2025. The current administration issued a series of executive directives that fundamentally expanded ICE's enforcement priorities. These directives removed many of the previous protected zones and restrictions that limited where and how immigration enforcement could take place. Under the new framework, airports, including international arrival halls, TSA checkpoints, and, in some reported cases, domestic departure gates, are now active enforcement zones. ICE officers and CBP agents have been granted broader discretionary authority to question, inspect, and detain individuals they identify as enforcement priorities. This is not hypothetical. There have been multiple documented cases in 2025, reported by immigration attorneys, verified by court filings, and covered by mainstream news outlets, of individuals being stopped, detained, or denied re-entry at U.S. airports. Some of these individuals were green card holders. Some were visa holders with valid documents. Some had been living in the United States for years. The bottom line is this: the rules have changed. And the 4 groups we are about to discuss need to understand exactly how those changes affect them. All right. Let us go through all 4 groups one by one in detail. Pay close attention because the details here really matter. 1. People with pending immigration cases or active removal orders. This is the highest risk group right now, and it is also one of the largest. If you currently have a pending case in immigration court, whether it is an asylum case, a cancellation of removal case, or any other proceeding, your name is in the Federal Immigration Database. Every single time you enter a U.S. port of entry, CBP officers run your name through that database. They can see your case status in real time. Now, here is where it gets serious. If you have ever had a removal order issued against you, even if it was years ago, even if it was stayed pending an appeal, even if you believe it was resolved, that order may still be active in the system. And under current enforcement priorities, CBP officers have the authority to act on that order immediately when you arrive at the airport. We have seen cases in 2025 where individuals who had lived in the U.S. for over a decade, who had valid visas, who were employed and had families here, were detained at the airport upon return from a family trip abroad because of a removal order that was years old and that they believed was inactive. If you have any pending case or any history of a removal order, do not travel internationally. Do not even consider it without sitting down with your immigration attorney first and confirming in writing what your exact legal status is and what risks you face at the border. This is not an area where guessing is acceptable. 2. DACA recipients and other deferred action holders. If you hold DACA, deferred action for childhood arrivals, this section is critically important for you. Please listen carefully. DACA does not give you lawful status. It gives you a temporary protection from deportation and work authorization. It does not, by itself, give you the right to travel internationally and return. For that, you need something called advance parole, a special travel document issued by USCIS that allows certain DACA holders and other deferred action beneficiaries to travel abroad and re-enter the United States. Here is the problem. In 2024 and into 2025, there have been documented cases of DACA recipients who had valid advance parole documents that were officially approved by USCIS, being stopped, questioned for extended periods, and in some cases detained at airports upon their return to the U.S. How is that possible? Because CBP officers have broad discretionary authority. Advance parole is a permission to apply for re-entry. It is not a guarantee of re-entry. A CBP officer can still make an independent determination at the port of entry. On top of that, the legal future of DACA itself remains deeply uncertain. There are ongoing federal court challenges that could affect DACA protections at any time. Traveling internationally as a DACA holder right now means rolling the dice on a program that could change status while you are outside the country. The advice from virtually every major immigration attorney right now is the same. If you hold DACA, do not leave the United States unless it is absolutely necessary. And if you must travel, consult an experienced immigration attorney before you book anything, not after. 3. Visa overstayers, including those with pending adjustment of status. This one catches a lot of people off guard. Let me explain exactly what the risk is here. If you ever stayed in the United States beyond your authorized period of admission, even by just a few days, you have accumulated what is called unlawful presence in your immigration record. This unlawful presence does not disappear over time. It stays in your file. Now, many people in this situation have since taken steps to fix their status. Maybe you married a U.S. citizen and filed an I-130 petition. Maybe you have an approved I-485 adjustment of status application pending. Maybe you have received other forms of relief. These are positive steps, but they do not erase the unlawful presence issue when it comes to travel. Here is the critical legal rule. If you accumulated 180 days or more of unlawful presence and then depart the U.S., you may trigger a 3-year bar that prevents you from re-entering. If you accumulated 365 days or more of unlawful presence and then depart, you may trigger a 10-year bar. These bars are automatic. They are triggered the moment you leave the country, regardless of what applications you have pending, regardless of your family ties, and regardless of how long you have lived here. Additionally, leaving the U.S. while an adjustment of status application is pending is, in most cases, treated as abandonment of that application, meaning your case is closed and you would have to start over. There are limited exceptions with something called advance parole, but this is highly specific to your individual case. If you have any history of overstaying a visa, please do not travel internationally without first consulting an attorney who can review your specific record and advise you on whether travel is safe. 4. Non-citizens with prior criminal records, including minor offenses. This is perhaps the most surprising group on this list, because many people with old or minor criminal records genuinely believe it will not affect their immigration status. In 2025, that belief is increasingly dangerous. Under the expanded enforcement priorities, ICE now treats a much broader range of criminal history as grounds for enforcement action. We are not just talking about serious felonies. We are talking about misdemeanors, old DUIs, even from 10 or 15 years ago, charges that were dismissed, arrests where you were never convicted, in some cases even traffic violations that were later upgraded to criminal charges. Why does this matter at the airport? Because when any non-citizen, Whether you are on a temporary visa, a student visa, a work visa, or even if you are a lawful permanent resident holding a green card, passes through a U.S. port of entry, CBP conducts a comprehensive records check. That check pulls your criminal history. It flags prior arrests, charges, and convictions, even old, seemingly irrelevant ones. If something flags in that system, you can be pulled aside for secondary inspection, questioned for hours, and in serious cases, placed into removal proceedings right there at the airport. We have seen green card holders, people who have been legal permanent residents of the United States for over a decade, placed into removal proceedings upon re-entry because of a misdemeanor offense from years earlier that they thought had been resolved. The rule is simple. If you have any prior contact with the criminal justice system, any arrest, any charge, any conviction, no matter how old or minor it seems, you need to speak with an immigration attorney before your next international trip. An attorney can review your record and help you understand whether you face any risk before you board that plane. Now let us step back for a moment and talk about what all of this means in practical terms, not just for the 4 groups we covered, but for all immigrants living in and traveling to the United States. If you do not fall into any of those 4 groups, always travel with your full set of immigration documents. This means your green card or visa stamp, your valid passport, and any relevant USCIS approval notices or receipt notices. Keep digital and physical copies of your most important documents in a safe, accessible place, both at home and in your travel bag. If you are questioned by CBP at the airport, be polite, be calm, and answer questions about your immigration status truthfully. Do not volunteer information that was not asked for. Know your rights. This is important. If you are a U.S. citizen, you cannot be denied re-entry to the United States. However, you can still be questioned and asked to verify your citizenship. If you are a lawful permanent resident, a green card holder, you have significantly more legal protections than a temporary visa holder. But those protections are not absolute. Under certain circumstances, your green card can be considered abandoned, and removal proceedings can be initiated even against lawful permanent residents. You have the right to remain silent. You have the right to speak with an attorney. If you are detained, do not sign any documents without fully understanding what they say, and do not sign anything that waives your rights without consulting legal counsel first. If you are detained or facing removal proceedings, contact an immigration attorney immediately. Many nonprofit legal organizations provide emergency legal assistance for detainees. Links are in the description below. For those in the middle of an immigration process, if you currently have a pending visa application, a pending green card application, or are in any active immigration process, international travel can seriously jeopardize your case. In many situations, leaving the U.S. while a petition is pending is treated as withdrawal or abandonment of your application. There are exceptions. Certain travel documents like advance parole can protect you, but these are very case-specific. Always confirm with your attorney before booking any travel. Before we close out, I want to give you a quick, practical travel checklist that every immigrant should run through before booking any international trip. Think of this as your pre-travel safety check. Step 1. Check your immigration status. Log into your USCIS online account or contact your attorney to confirm your current status, whether any applications are pending, and whether any orders or flags exist on your record. Step 2. Check your travel document validity. Your passport should be valid for at least 6 months beyond your travel dates. Your visa or green card should be current and not close to expiration. Step 3. Check for any criminal history flags. If you have ever been arrested, charged, or convicted of anything, even a minor offense, speak with an immigration attorney before traveling. Do not assume it is not an issue. Step 4. Check for unlawful presence. If there is any period in your history where you may have stayed beyond your authorized time, consult an attorney to understand if travel triggers any bars to re-entry. Step 5. Get it in writing. If your attorney gives you clearance to travel, ask for a written memo summarizing your status. Carry it with you. It may not be legally required, but having documentation of your status on hand is always a smart precaution. Step 6. Have an emergency contact ready. Before you depart, make sure a trusted family member or friend has the contact information for your immigration attorney and knows what to do if you do not return as expected. Let us bring it all together. Today we covered the 4 types of immigrants who face the most serious risks when traveling right now in 2025. Number 1. People with pending immigration cases or removal orders. Number 2, DACA recipients and deferred action holders. Number 3, visa overstayers, including those with pending adjustment of status applications. And number 4, non-citizens with any prior criminal history, no matter how old or minor. We also walked through what all immigrants should know about their rights at airports, what the practical steps are before any international travel, and why staying informed is one of the most powerful things you can do to protect yourself and your family in this environment. The U.S. immigration landscape is changing fast, but knowledge is protection. And that is exactly why this channel exists, to make sure you always have access to the information you need, clearly explained in plain language when it matters most. If this video helped you, please give it a thumbs up, drop a comment below with your questions, and share it with anyone in your community who might need to hear this. Every share could protect someone. Thank you for watching Immigration Radar USA. Subscribe for the latest U.S. immigration updates, and we will see you in the next one.